Hi everyone, my name's Tom Fairclough. I'm a barrister at 2 Temple Gardens, and I'm giving this talk on developments in vicarious liability law. We've had a lot of sign-ups, so just by way of brief background, for this year until the end of July, I'm working at the Supreme Court and Privy Council as a judicial assistant, first to Lady Auden and now to Lord Legate. In that role, I've worked in a variety of cases in almost every area of law, the highest profile of which was probably Miller and Cherry, also known as the prorogation cases, back in September. And in terms of employment law, I've worked on cases involving Polky unfairness in the Privy Council, Royal Mencap Society, which is about sleep-in workers and the national minimum wage, and in about a month or so, we'll be working on Uber, which is all about whether Uber drivers are workers or not. Away from the Supreme Court, I work in all of Chamber's main practice areas, but have a particular interest in employment law and employers' liability. Previously in Chambers, I've worked on appeals to the EAT in unfair dismissal cases, cases involving non-delegable duties of care for posted workers who are injured in the new workplace, cases involving injuries that happen on company retreats, discrimination, victimization, harassment claims, and so on. So that's me. Just before the talk itself, and just by way of advance notice, I've previously produced a guide on vicarious liability, which will be sent out after the talk, and there will be time for questions at the end. So if you have any questions, please feel free to send them using the Zoom chat function throughout the talk, and then I'll pick them up at the end. Can I also ask, if you have your microphone or video on, can you just make sure that it's muted and video off for the talk? Thank you. So vicarious liability, 2 strands. It's often in issue and raises 2 distinct but important questions, both of which have been addressed by the Supreme Court in April of this year, and both will be addressed in this talk. First, who is a business responsible for? So what kind of relationship gives rise to vicarious liability? And second, for what conduct or actions is a business responsible for? Clearly, not all tortious conduct by an employee is the employer's responsibility. Now, for decades, both of these questions have been litigated at the highest level, and both have created issues. In fact, such are the problems with finding a principled or consistent approach that in a case called Imperial Chemicals Industries Limited in 1965, Lord Pearce said, "The doctrine of vicarious liability has not grown from any very clear logical or legal principle, but from social convenience and rough justice," which isn't a particularly helpful guide for when trying to advise clients. But, as I've said, the Supreme Court has recently given some guidance on both strands of vicarious liability, which will be comforting to employers. So, the first strand, who are you responsible for? Cases in recent years have caused some consternation amongst businesses, as the scope of vicarious liability has seemingly expanded into an ever wider array of relationships. And 2 cases have been seen to symbolise this. Various Claimants and Catholic Welfare Society from 2012 in the Supreme Court, also known as Christian Brothers, and Cox and the Ministry of Justice, which is a 2016 Supreme Court case. Taking each in turn, in Christian Brothers, the tortfeasor had sexually abused children at a school, and the victims sued the defendant society responsible for the school. The tortfeasor was a member of the Christian Society, but he wasn't an employee. And employment status alone didn't determine the case, as it might once have done. Lord Phillips said, if the relationship is sufficiently akin to employment, then vicarious liability may be found. And Lord Phillips gave 5 factors that go towards justifying the imposition of vicarious liability in the employment sphere, and made clear that if these factors are present in other types of relationship, vicarious liability can be found. And these factors were, first, the employer is more likely to have the economic means to compensate the victim. Second, the tort will have been committed as a result of activity being undertaken by the employee on behalf of the employer. Third, the employee's activity is likely to be part of the business activity of the employer. Fourth, the employer, by employing the employee, will have created the risk of the tort being committed. And fifth, the employee will, to a greater or lesser degree, have been under the control of the employer. Applying those factors in Christian Brothers, Lord Phillips found that the defendant society was vicariously liable for the tortfeasor's actions. The society was hierarchical in nature, the members undertook activities for the society's benefit, and the society gave rules to the members. So this was sufficiently akin to an employment relationship to justify vicarious liability. Now that case was considered and followed 4 years later by the Supreme Court in Cox, where a prisoner was required to carry out work and negligently dropped a sack of rice onto the prison catering manager. The prisoner was not an employee, and yet Lord Reid said the Ministry of Justice was vicariously liable for his negligence. Lord Reid considered that vicarious liability could be imposed when the tortious actions are done as an integral part of the business activities of the defendant for the defendant's benefit, and where the risk of the tortious action occurring was created by the defendant, assigning those activities to the tortfeasor. Now, given those two cases, the businesses were concerned that the law was recognising a wider range of relationships than the strict employer-employee relationship as giving rise to vicarious liability. But Barclays Bank and Various Claimants, which is a 2020 Supreme Court case, has, if not quite reversed the tide, then at least stemmed it, and Barclays' facts can be briefly summarised. Dr. Bates was a medical doctor who worked for various businesses, such as hospitals and insurance companies, and amongst other things, he undertook medical assessments for prospective employees. At the time, Barclays had a policy of giving a job upon satisfactory completion for medical assessments, and Barclays arranged appointments with Dr. Bates to examine prospective employees and sign them off, and he was paid for each report he produced. Importantly, he wasn't paid a retainer, so there wasn't some sort of standing payment regardless of how many examinees Dr. Bates examined. Now, it was alleged by about 120 patients that Dr. Bates had sexually assaulted examinees that Barclays sent to him. And Dr. Bates died, and having no claim against the estate through lack of funds, the claimant sought to hold Barclays vicariously liable for his actions. And the High Court and the Court of Appeal said that Barclays was vicariously liable because, in short, of the reasoning in cases like Cox and Christian Brothers, the Court of Appeal focused on the control strand of Christian Brothers and said that Barclays had control in organising the examiner, the time, the place, what the examinations would involve, and so on. The Court of Appeal's decision in Barclays, which seemed to expand further the role of vicarious liability, was followed in a High Court case called Levitt and Euro Building and Maintenance Contractors Limited, which is a 2019 High Court case involving labour-only subcontractors, which were not employees, but which were described as quasi-employees, falling within the sufficiently akin to employment framework. It's worth noting that Levitt has an outstanding appeal, and so we will see where that goes, given Barclays in the Supreme Court, because the Supreme Court overturned the Court of Appeal in Barclays. And in a reasonably short and pithy judgment, Lady Hale made clear that there is nothing in the sufficiently akin to employment test from Christian Brothers, or in Lord Reid's judgment in Cox, to doubt the distinction between work done for an employer as part of the employer's business, and work done by an independent contractor as part of business on his own account. And that's paragraph 22 of Barclays. Cases like Christian Brothers were said to be useful in the more difficult or borderline situations. But for cases such as this, Lady Hale said you just applied the carrying on business on his own account test. When you did that, she said, it was clear that Dr. Bates was not sufficiently akin to an employee of Barclays. Lady Hale said, yes, he did work for them, but she pointed out, well, that's true of many people, the window cleaners and the auditors. Dr. Bates wasn't paid a retainer, and he was free to refuse work from Barclays, and therefore Barclays' appeal was allowed. Now, the factors Lady Hale looked at, the fact he's not paid a retainer, the fact he was free to refuse work, the fact he did similar work for others, will likely be present in many, if not most, independent contractor cases, and I would argue signal clearly away from a relationship giving rise to vicarious liability and will provide some comfort for businesses facing the prospect of litigation. So that's the first strand. What kind of relationships are you responsible for or confound vicarious liability? But we then get to the second strand. For what actions are you responsible? Now, it's clear that even if you are, in theory, vicariously liable for another person's conduct, it won't be all tortious action or every action that you're liable for. Clearly, if someone is my employee and whilst, I don't know, they're in holiday in Cornwall and negligently cause a road traffic accident, that's not my responsibility. That has nothing to do with me. However, the range of conduct that is sufficient to fall within the vicarious liability framework or relationship has seemingly expanded in recent years. So the general test was given in a case called Dubai Aluminium Company Limited in 2003, where at paragraph 23, the House of Lords said, the wrongful conduct must be so closely connected with acts the partner or employee was authorised to do that the wrongful act may be regarded as done by the partner whilst acting in the ordinary course of the firm's business or the employee's employment. That is what we would usually term the close connection test. You're responsible for your employee's conduct if it has a sufficiently close connection with the employment. However, the application of that test has always been difficult and has always been litigated and hotly contested, and particularly in situations involving, for example, intentional wrongdoing. And that difficulty comes from, as was recognised in the House of Lords, in the Supreme Court in Christian Brothers, the fact that the close connection test, and I quote, tells one nothing about the nature of the connection required. And we do have some guidance. So a Canadian case called Baisley, which has been approved by the Supreme Court here, gives 5 non-exhaustive factors. So we look at the opportunity that the employment afforded the employee to abuse his power. Second, the extent to which the tortious act may have furthered the employer's aims. Third, we look at the extent to which the tortious act was related to friction, confrontation, or intimacy inherent in the employer's business. Fourth, we look at the power the employee had over the claimants. And finally, fifth, the vulnerability of the claimants to the wrongful exercise of the employee's power. But even those 5 factors, how they interrelate and interact is difficult. In a case involving Sainsbury's Supermarkets in 2013, an employee was known to harbour extreme views about European workers coming to the UK. Very sadly, he murdered a co-worker of Eastern European descent in the Sainsbury's supermarket aisle with a knife. And before the murder, the victim had complained to Sainsbury's about the employee's racist views. And yet, on appeal to the Inner House of the Court of Session in Scotland, the court found that Sainsbury's was not vicariously liable. In particular, the Inner House noted no matter how much the tortfeasor's employment was looked at, it was not possible to hold that the employment carried any special risk that the employees or an employee would harass or harm another employee. And the limits of that close connection test have recently been examined in the Supreme Court in 2 cases involving Morrison Supermarkets. Now, the first is Muhammad and Morrison Supermarkets, which is a 2016 Supreme Court case. And to distinguish it from the other Morrison's case, I'll call this one Muhammad. Now, in that case, in which incidentally members of 2TG acted in the Supreme Court, the claimant stopped at a petrol station operated by Morrison's, went to the customer counter and asked, rather bizarrely, if an employee could print documents from a USB stick for him. The employee responded in aggressive language and ordered the claimant to leave, and the employee then followed the claimant out onto the petrol forecourt and assaulted him in a racially motivated attack. This went to the Supreme Court, and Lord Toulson said that the court must consider 2 matters. What were the functions or field of activities entrusted to the employee, and was there a sufficient connection between those functions or fields of activities and the tortious conduct? It's worth noting that fields of activities, on an initial glance at least, seem somewhat wider than the normal close connection test. There'll be more on that shortly. Lord Toulson was critical of cases that had declined to find vicarious liability, where it couldn't be said that the conduct was somehow in pursuit, albeit wrongful pursuit or erroneous pursuit, of the individual's employment or the employer's business. In the case at hand, the Supreme Court said that the employee was acting within the field of activities entrusted to him when he racially assaulted the claimant. And factors leading to that conclusion were as follows. First, it was the employee's job to deal with customers. His conduct in answering the claimant's request for printing was seen to fall within the field of activities assigned to him. Second, what followed was part of a seamless episode, so there was some sort of causal connection between the field of activities and the tort, the assault. Third, when the employee followed the claimant, he told the claimant in aggressive language that he was never to come back to the petrol station. So this was an instruction whilst carrying out the assault to keep away from the employer's premises. And fourth, even though the employee was motivated by racism rather than any misguided desire to further his employer's business, Lord Torsten specifically said, and I quote, "Motive is irrelevant." So this case, whilst in Mohammed the Supreme Court stressed it was not expanding the law, was at the very least, taken to have increased the range of conduct that falls within the vicarious liability framework. In Levitt, for example, the 2019 High Court case currently on appeal I mentioned before, involving a subcontracted labourer attacking another labourer, Mohammed was followed and vicarious liability found. Now, whilst the High Court was at pains to say not all employee-on-employee assaults will give rise to vicarious liability, it found in that case 4 factors that go towards finding it. First, the assault occurred during working hours on the work premises. Second, the background of the assault was an argument about work. Third, the assault occurred within minutes of the initial argument, and so forms that series of unbroken events. And fourth, the weapon that was used in the assault was work equipment. Further, it seems that Mohammed, taken to its logical extreme, means that an employer is liable for his employees' racially or sexually motivated criminal act if there is some degree of causal nexus between the tortious conduct on the one hand and the relationship with the employer on the other. Lord Torsten said motive doesn't matter. And so, again, taking that to its logical extreme, an employer is responsible for an employee's actions, even when such actions are predicated on the employee's own motivations. Now, unsurprisingly, Mohammed was greeted with dismay by employers and businesses, but was welcomed by claimants. And again, whilst the Supreme Court said Mohammed didn't change the law, a clear rowing back from Mohammed has been sounded in the second Morrison's case, which the Supreme Court gave judgment on in April of this year, and that's Morrison Supermarkets and Various Claimants. In that case, the respondents were 9,263 of Morrison's employees or former employees, and they brought a claim due to the tortious actions of a Mr. Skelton. Mr. Skelton was an employee of Morrison's. He's no longer an employee of Morrison's because he published personal information about the respondents on the internet. And he did this as a result of a grudge held against Morrison's following some trivial or otherwise minor internal disciplinary proceedings. It's worth noting Mr. Skelton is now spending a long time in prison as a result of his actions. And the respondents, clearly because Mr. Skelton didn't have the funds, brought a claim against Morrison's alleging it was vicariously liable for Mr. Skelton's tortious conduct. And there was no issue about whether or not he was an employee, and therefore there was the potential for vicarious liability. It all came on the second limb of vicarious liability. And the High Court and Court of Appeal both found that Mr. Skelton's actions did satisfy the close connection test. And as such, Morrison's was vicariously liable for those actions. And it's important to look at the Court of Appeal's reasoning, which relied on Mohammed. And at paragraph 76, the Court of Appeal said, in Mohammed, the motive was of the foul-mouthed petrol pump attendant was personal racism, rather than a desire to benefit the employer's business. But, said Lord Torsten, motive was irrelevant. Despite the appellant's submissions on the point, we do not accept that there is an exception to the irrelevance of motive, where the motive is, by causing harm to a third party, to cause financial or reputational damage to the employer. Unsurprisingly, this reading by the Court of Appeal of the reasoning in Mohammed was seen as confirming an expansion of the type of conduct that an employer would be responsible for. And when Morrison's appealed to the Supreme Court, it was equally unsurprising that the respondents relied heavily on Mohammed, given that the Supreme Court had only handed down that judgment 4 years previously. But in a unanimous judgment given by Lord Reed, the new president of the Supreme Court said that Mohammed had to be read as a whole and was not intended to effect a change in the law. The Supreme Court allowed Morrison's appeal, and I think there are four main points to take from that. First, whilst case law talks about whether the wrongful conduct can fairly and properly be regarded as occurring in the course of the employer's business, that is not an invitation to decide cases according to some abstract, or to use the more vernacular language, woolly ideas of fairness or justice. It requires the courts to look at past case law and precedent and the guidance it gives. That's made clear at Morrison's paragraph 24. And so the factors in cases such as Dubai and Baisley, which were mentioned before, will be influential. Second, and this is at paragraph 26 of Morrison's, the courts must assess the activities entrusted to the employee and then decide whether there was a sufficient connection between those activities and the tortious actions. And we're told that's all that was meant by fields of activities in Muhammad. It's no different to cases such as Dubai. Third, Muhammad is said at paragraph 28 of Morrison's not to be authority for the proposition that all one needs to establish for a sufficiently close connection is a causal connection, a series of unbroken events between the employment and the wrongdoing. When Lord Tulson in Muhammad spoke about a seamless episode, he wasn't referring to a series of events, but instead the capacity in which the employee was acting when the tortious conduct occurred. And finally, and I think this is truly vital for intentional wrongdoing, at paragraph 29 of Morrison's, we're told that whilst read in isolation, the statement motive is irrelevant might be misleading. Lord Tulson made clear that there was a sufficiently close connection in Muhammad between the employee when engaging in his racially aggravated assault and the fact he was purporting to act for his employer's business. The question of whether a tortfeasor was acting on his employer's business, even in a misguided way, or for personal reasons, is, we're told, plainly important. Now, given those points, Lord Reed at paragraph 31 said that the lower courts, so the High Court and the Court of Appeal, from which I've cited, misunderstood vicarious liability. He said that the key points here were that the disclosure of information on the internet was not part of Mr. Skelton's field of activities. That simply wasn't his job. And whilst there may be an unbroken chain of causation, that is not in itself sufficient to find or found vicarious liability. And motive is not irrelevant. Whether he was acting for purely personal reasons is, we're told, highly material. And at paragraph 35, Lord Reed said, and again, I think this is a crucial point, the mere fact that Mr. Skelton's employment gave him the opportunity to commit the wrongful act is not enough in and of itself to impose vicarious liability. Mr. Skelton was clearly not engaged in furthering his employer's business, even in some misguided way. So, the examples of someone speeding whilst delivering goods for his employer. Mr. Skelton was pursuing a personal vendetta and seeking vengeance. That is not closely connected with the acts he was authorised to do. And as such, his actions did not fall within the vicarious liability framework. Now, unsurprisingly, Morrison's, much like Barclays, has been welcomed by employers and businesses. Now, that summarises the law in Barclays and Morrison's, which is the latest word from the Supreme Court. I think there are three practical points to take from those cases. First, as to who businesses are responsible for, Lady Hale in Barclays has reiterated and reaffirmed at the highest level the distinction between those in business on their own account and those acting as part of somebody else's business. Now, this is an inherently fact-sensitive exercise for the trial judge, and care should be taken at the earliest possible stage to check those relevant facts. So, for example, is the tortfeasor on a retainer or not? Does he work exclusively for the defendant business or not? How much practical control does the defendant business exercise over the tortfeasor? How much, if any, guaranteed work does the defendant business provide to the tortfeasor? Failure to check these facts at an early stage could lead a party into difficulties at a later stage. So it's really very key to get that information from a client ASAP. And I think that's particularly important in the more complicated cases, which might involve, for example, subcontracted or posted workers, where the information might not be held by the defendant business, but by the business to which the employee was posted, or the worker was posted. Second, as to practical points on what actions the business will be responsible for, this is also fact sensitive. But again, it's important early on to know what the case is regarding, for example, the tortfeasor's intention and the connection, if any, that the wrongful act had to the employment. A distinction between Muhammad and Morrison's, and it's important to remember that the Supreme Court has said both Muhammad and Morrison's is good law, may be said to be that in Muhammad, the tortfeasor was motivated by racism, but was in fact telling the victim not to come back to the place of employment. So there is some connection there. Whereas in Morrison's, the sole aim was to damage the employer. So knowing your case on this early will be very helpful when it comes to things like pleadings. And And third, as a practical point, claimants, I think, will be disappointed by Barclays and Morrison's. But it is important to bear in mind that employers may well owe personal duties of care to their employees or to those they interact with, which may have been breached by putting, for example, an employee at risk of the tortfeasor's actions. So claimants that might previously, under Cox or under Mohammed, may have doggedly pursued vicarious liability claims, would be advised to give serious consideration to any personal duty of care the defendant business may have owed them and may have breached. And that just leaves some questions going forwards, because whether Barclays and Morrison's represent a change in the law or a clarification in the law is to an extent unimportant. The simple fact is they'll be welcomed by the defendants and they'll cause concern to claimants. They do give some certainty in this important area of law, but I think a word of caution is needed, because both do raise questions that will ultimately have to be decided through litigation. And I think there are perhaps three questions that really do still need to be answered. So first, if motive does matter insofar as it goes to whether an employee was acting in the furtherance of his employer's business, how does a court begin to assess that? What happens if a case, such as Mohammed, I suppose, has a mixed motive, so partly to do with your employer, but also animated by personal hostilities? Second, where do you draw the line between pursuing a personal action and carrying out an unauthorised action in purported furtherance of your employer's business? Because that's key, and yet that line, I think, remains at best fuzzy. And third, given the increasing complexity of the gig economy, atypical workers, posted workers, and subcontracting in a modern global economy, ultimately, who will employers actually be responsible for? Now, Lady Hale suggests not their window cleaners, but what about the people that come in to provide training to a business, or those that provide catering to a business? A good example might be teaching at universities, which increasingly involves atypical workers. And so I was thinking a personal example would be I teach at Cambridge and have done for 4 or so years. And in that role, contractually speaking, I'm self-employed, but I teach on college premises using a syllabus set by the university. The students are allocated to me by their colleges, and clearly teaching is absolutely central to what the university does. And yet it's not clear to me whether the university or colleges I teach for would be vicariously liable. Inevitably, those kinds of questions will always depend on their facts, but so far, I'd argue we're still a long way from complete clarity or certainty in this area. And so whilst there is some pragmatic principle at play, and you can see that in the recent Supreme Court case law, we are still, I think, in an area involving a fair amount of rough justice. Now, those somewhat rhetorical questions end the formal part of the talk, and I'd just like to thank everyone for signing up and spending your mornings watching. As I said at the beginning, I've produced a guide on Barclays and Morrison's, which should be sent round to those who signed up for the talk, and a recording of the talk will also be emailed out for anyone that wants to watch it again. There is time for some questions, if anyone has any, and I'll check the chat box in a minute. But if you'd rather ask your questions by email, then my Chambers email will be put up at the end, and it's also on the guide we'll send out and on my Chambers profile on our website. And thank you again for your time.